So I'll go ahead and hear from you, Mr. Rinehart.
Thank you.
Your Honor, on the plaintiff's motion for summary judgment, the plaintiff is obvious from the record, the owner of a registered trademark on the principal register.
For certain goods and services.
It's a service mark, and it is on the expression "my school," which is identical to the disputed domain in this proceeding, of course. Now, the motions touched a little bit on whether this mark is descriptive or suggestive. The mark denotes a school, which is a tangible place, a building, an institution. If my client were in the business of selling schools, or if they owned a school, I would say that the mark would be more descriptive. But my client is in the business of offering a service, commentary for alumni of different schools, marketing services relating to schools. The U.S. Patent and Trademark Office determined that this mark was suggestive and thus inherently distinctive.
Well, that's only suggestive as to the uses that it was in its application.
That's right. That's right. Yeah.
It's not that the mark is suggestive as to all uses, only those uses set out in the application.
That's accurate, Your Honor. However, I would point out that opposing counsel has argued that it's descriptive even with respect to those services. And so we might make some progress today if there was some sort of understanding that it is suggestive with respect to those services. Now, the defendant is, the plaintiff would characterize them as a cyber squatter. They'd object to that characterization. But they own, it's undisputed, over 50,000 domain names. In the last 12 months, they've sold, and there is some confidential material that
well, the only thing, and just to get you up to, the only thing that is really confidential is the explicit terms of the settlement agreement in Canada.
Okay.
I don't think there's any, and Mr. Wessel, I'm wrong. I think that's the only thing that I have allowed them, so that they own 50,000 domain names, that they've sold 400 or 500 domain names in the last year. Right. All of that information is now part of the public record, given the nature of this proceeding.
Okay. Thank you, Your Honor. The amount of domain names they've sold over the last 12 months is 594. I believe that's what the exhibits show. We went through and tried to look at how many of those domain names are trademarked. Keep in mind, none of the domain names are actually being used in commerce. They're all just sitting on these, the defendant is sitting on these domain names.
Well, they're two different things. Sitting on them and using them to direct traffic somewhere else is different. I mean, I don't understand why you would say that them making use of the domain name that generates $700 a month income for them isn't use in commerce.
Well, use in commerce would be use in connection with an offering of a good or service. And they're resolving these domain names, each of them, to a generic landing page. The landing page is the same at every domain name. The only thing that differs from one domain name to the other are the ads, the third-party ads that are shown on the domain name. And this is not use in commerce. The Trademark Office wouldn't consider it to be use in commerce just to have a generic landing page at the domain name. And they generate, yes, cost per click, or also called pay-per-click revenue, from the ads that are displayed on these generic landing pages. The ads that are displayed, according to the defendant in his deposition, they're chosen via an algorithm that he's hired a third party to use. So a third party controls the placement of these ads on the domain. But he registered these domains with the intent to benefit from the traffic in these expressions, with the intent to sell these domain names, keeping in mind that 144 of the last 594 he sold are trademarked, to benefit from the sale of these to other parties. Now, the Fourth Circuit's held, even this Court's held, that it's hard to prove intent. But we have evidence here that I think proves it. We have a history of cybersquatting on the part of the defendant. there's some dispute over whether he's lost one UDRP case or 3 UDRP cases prior to this, but I hope that the memorandum make it clear that he's lost 3, which are all 3 that were filed except the one that preceded this case. He's been banned, the evidence shows, from other websites for committing fraud and falsifying impressions. Now, this is just the evidence that we have, that we've tried to attach to show intent.
What is this 8 or 9 years ago that he was somehow or another banned from the internet, your argument, have to do with cybersquatting?
Well, we're trying to show intent. We're trying to show bad faith intent. And establish...
You don't think filing serial UDRP proceedings could show bad faith intent?
You mean on the part of the plaintiff?
Yeah.
No, Your Honor. The UDRP cases are entitled to no deference. And there were 2 UDRP cases that preceded this case. One was in 2010, one was in 2014. The first did not involve the current registrant.
No, but it involved the same domain name.
Well, it didn't involve the same domain name, but the ruling in that case was against the complainant because the domain had been registered before he accrued trademark rights. In the second case, the domain was registered clearly after he accrued trademark rights. And so there was every justification in the world for filing the second UDRP case. The first did not involve the current current defendant.
Well, I understand.
And they claim to have had no knowledge of it. So it wouldn't have provided a basis for them.
No, and there's difference between registration and use, and we'll get into that. But I just didn't see any significance to this information having to do with some website or some posting 8 or 9 years ago having to do with the issues that I need to deal with on your motion and their motion.
I understand, Your Honor, but it may be attenuated, but it does show that at least one other party believes the registrant in this case is doing things to try and inflate traffic, to try and generate increased cost per click revenue from domains that they're not entitled to. By falsifying impressions, they're increasing the revenue that they're generating from cost per click ads. And so it demonstrates a willingness on the part of the registrant or the res defendant to break the law to increase revenue. And so that would be the relevance, if any, Your Honor. And we believe that this is really just a simple cybersquatting matter. There was a lost UDRP case before this. All, in my experience, or I guess I shouldn't say all, but most interim cases before the Eastern District follow lost UDRP cases. The UDRP says you can file a lawsuit before, during, or after the case. And the courts have repeatedly ruled that they're entitled to no deference or reviewed de novo. In the court's de novo review, we hope that the court sees that there's a valid and subsisting trademark. The disputed domain is identical. The defendant has a history of registering trademark domains and selling them. And that this is really a case that's more simple than it seems from the memoranda of the defendant. The defendant has sent hundreds of discovery requests in this case and done everything they can to try and find some defense, something to hang their hat on in some sort of fishing expedition. They claim that the defendant's or the plaintiff's use of the mark was token at first. Well, that's not really a cognizable defense to trademark use, that it wasn't as extensive as someone else's use. It was being used. They have tried to assert that there's an irregularity on the specimen and statement of use that were submitted in connection with the trademark filing before the U.S. Patent and Trademark Office. And
well, I think your client admitted in his deposition, didn't he, that my school was not part of the use in commerce. Is that right?
He did, Your Honor.
Well, then what did you present to the Trademark Office that shows the use of the trademark My School in Commerce as a specimen in 2008?
In 2008, it was originally filed, the trademark application, as a 1B intent to use application.
Right. That was in 2007.
That was in 2007. In 2008, it was converted to a 1A. And the specimen, the statement of use that was filed in 2008, was a screenshot of the plaintiff's website at myschool411.com. It showed the website. It showed the mark on the website.
Well, where did it show the mark on the website other than what was then typed in or inserted that wasn't really part of the use in commerce? That was my question.
I believe, Your Honor, that let me see if I can find the specimen, but I believe it shows the mark in the top corner.
Well, that's what was added, isn't it?
No, the text that was added.
Show me the exhibit then, and then tell me where it is.
Okay.
This may not really be in your motion, but it could be in.
Your Honor, I believe it's included as an exhibit to defendant's original motion for summary judgment, and I don't have the exhibit right here in front of me.
All right,
perhaps I can.
It might be. I'm close to it, if not there. Is it O? You've got Exhibit O to defendant's memorandum in support of its motion for summary judgment, which are 2 pages. Is that right?
I believe that is right, Your Honor.
Mr. Rinehart, you don't have the pleadings with you?
I do, Your Honor. I just don't have all the exhibits. I hope to bring them in electronically. They were so voluminous. But I can represent to the court, Your Honor, that the text myschool.com is not the mark that's shown in the specimen. It's just, it was added almost as a header to the top of the specimen.
Right. And so the only thing that shows up is school, Bad Idea Magazine, message board, Springfield Valley High School, about messages. I mean, what I see doesn't have my school as a part of any use in commerce. If you took out what was added, that is the myschool.com, which your client has said was not part of what was actually being used in commerce.
That's accurate, Your Honor.
If you look at the remainder of the exhibit, I'm asking what in the remainder of that exhibit shows the use of my school in commerce.
Well, it's shown in the MySchool 411 URL, which is accurate.
So the footer that says www.myschool411.com message board, you're saying that's the use of the My School mark in commerce?
Well, it does show the My School expression, yes, in the specimen. The parties have agreed that that's accurate. I believe that the title of the website, My School, is shown in the specimen, and if it's not there in your documentation, it was cut off. Perhaps opposing counsel can help us understand that. It is shown at the top of the website.
Okay. All right.
Anyway, these are the defenses, and this is what's the items that have become an issue in this motion.
Well, and one of the issues you have to show is that you have a valid and subsisting trademark, right?
However, the opposing counsel appears to be trying to advance some sort of fraud counterclaim, which was dismissed, both in the deposition and in this motion. It appears that they're doing that.
Well, they're asserting as an affirmative defense that you don't have a valid trademark.
But in arguing over intent, in arguing over what the specimen, whether the specimen that was submitted has some sort of irregularity, they seem to really be advancing a fraud counterclaim, which is irrelevant to the.
Well, if you have not submitted sufficient information to the trademark office, or have submitted false information, if it's false, and have obtained a trademark based on either insufficient or false information, then you shouldn't have a valid trademark, right? I mean,
I would say that that's right, but that the mechanism for attacking its validity would be a counterclaim. An affirmative defense is not a vehicle before the court upon which someone can seek relief.
No, but it can not be found if you're asserting trademark infringement. And let's just look at a basic trademark infringement case. If you were asserting trademark infringement, the defendant in that case could say, I'm not responsible for trademark infringement because you don't have a valid trademark. Same with copyright infringement, same with patent infringement. You can bring defenses to what is a material element of a claim. That is, in order to assert patent, copyright, or trademark infringement, you have to have a valid patent, copyright, or trademark.
The defendant is asking for the trademark to be canceled.
I understand that, and that may be a stretch as far as the relief. Mm-hmm. But the issue that I'm asking is, that, talking about now is, in order to prevail on a cybersquatting or cyber piracy claim under the ACPA, you have to have a trademark. And I agree that the registration gives you a presumption of validity. They have raised information that calls that into question. You still have the burden of proof, right? You recognize that it's only, you still have the burden of proving the element that is required to show trademark infringement, that you have a valid trademark. That's
right, Your Honor. And for what it's worth, in the deposition, this question was explored by the defendant. He was asked, the plaintiff was asked about this specimen. He was asked about his statement of use. And the parties agreed that he did begin using this trademark on the date that he filed the specimen, December 8th. But they've asserted in their memoranda that it was token use, that it was somehow insignificant because there weren't enough users. And so the use is not disputed. It's just
it's the uses to all categories is disputed, right? The alleged use that shows up on the specimens that you have isn't necessarily consistent with both classifications that you've got in your mark, right?
Well, I think that all the services in the mark are shown on the website.
Advertising services are shown up in that?
Well, they're shown on the website. They were shown on the website at the time. The trademark holder is required to submit only one specimen of use, not a separate specimen for each subclass, only a specimen for each international class. And so that specimen it's only required that it show one of those subclasses.
And at the time, there were, 15 or 20 people, most of which were part of the development team?
There were at the time it began, the day it went into use, but within a year there were 2,000.
All right, so anything else on the validity of the trademark as it relates to the goods and services, or the services that are set out in the application?
No, Your Honor. That's all I have on that point right now. Perhaps I can save any further arguments for rebuttal. But I think the other side will stipulate that it was being used as I've described.
All right. Well, what about the bad faith intent to profit from the mark? You haven't made any argument on that yet.
Well, intent is a difficult thing to establish. What we have tried to show is we've tried to show that the defendant has admitted familiarity not just with the Uniform Domain Name Resolution Policy, the UDRP, but also the ACPA, the Anti-Cybersquatting Consumer Protection Act. He admitted as much in a couple of different places in his deposition. We've referred to the court to those admissions. The defendant has admitted that all of the domain names that he has registered, 50,000 or more, may be trademarked. I believe that there has not been any submission to the court that the demonstrative exhibit we submitted showing 144 of the last 594 domains that were submitted were trademarked. They haven't denied that. And so these things show that the defendant is familiar with the cybersquatting laws, that he understands he's selling trademark domains, and demonstrate a bad faith intent to profit. The only argument that the defendants have advanced for safe harbor, for believing their registration was valid, was the first Uniform Domain Name Resolution Policy.
No. Their main argument is we didn't know that there was a trademark for my school. And, Mr. Rinehart, you said on no less than 6 times in your pleadings that you have filed here that there is evidence showing that the registrant knew of the trademark at the time it was registered. I need you to explain to me how you can make those statements 6 times in pleadings that you have filed with the court.
Okay, Your Honor. This gets into the issue of actual notice and constructive notice.
No, and you said actual.
Right, and we believe that the defendant had both actual and constructive notice.
Well, what evidence do you have?
The evidence is the email thread that's included as Exhibit K.
So let's just get the time frame down. The registration you now have acknowledged was in March of 2013.
Mm-hmm. Yes,
right?
Your Honor. Between March 1st and March 14th of 2013.
And this email that you say shows that they had knowledge of the trademark in March of 2013 is dated September 2014. Is that right?
It is. It's September 4th, 2014.
All right. So how does an email and knowing how they claim that email came into existence, how does the existence of an email on September 4, 2014 establish that they had knowledge of something 18 months earlier?
It's the content of the email, Your Honor. The defendant, Yonatan Belousov, is emailing the prior registrant in 2010 and discussing a case in 2010 that involved the trademark and demonstrating a familiarity with that case. There is no introduction. Hi, my name is Yonatan. Do you remember this case? It's an obvious familiarity that exists between the parties. Any reasonable person would read that email and know that they both knew about it.
Well, no, they knew each other.
Right.
And there was no, I mean, it's clear that they knew each other before 2014.
It is, but I believe, Your Honor, that it's equally clear that they knew the case. They immediately launched into a discussion of the case. He says, I need the documents from that case. He says, okay, I'll send them to you. There's not any question, any inquiring about whether he was the proper party to the case. And as the complaint was originally filed, we believe the registration date was the date of the privacy guard, which went on after this email. Now, I think this email alone shows knowledge of the case in 2010.
Knowledge of the case on September 4, 2014. I still don't understand how you say that shows knowledge of the first UDRP proceeding or the trademark, actual knowledge of the trademark, any earlier than that email.
Well, it's a twofold inquiry. First, if you understand or if you know that the UDRP case existed in 2010, you know the trademark existed because the trademark underlied the UDRP case. So the question is, did he know of the UDRP case? And the email shows not that he acquired knowledge that day, but that he acquired it before. And the earlier case existed in 2010.
Well, but was it a day before? Was it a week before? Was it 2 hours before he sent that email? What other than pure speculation is it that he knew back in March of 2013 of the first UDRP proceeding and of a registered trademark for my school?
We would like to have more evidence of that. We'd like to get the emails from his attorney. That was the purpose of the motion to reopen limited fact discovery. But
Well,
the only
I heard that motion at 10.
I understand.
The reason I denied it, you can get the transcript and read it again, but you had that information on June 1. You knew when they were saying they had notice of it. You had that email as of June 1. You deposed him on August 14. You had a full opportunity to ask him questions. The only objection that was made at the time was not to tell him about advice. And that was a proper objection not to talk about advice. You had the opportunity, and he told you he got it from his lawyer. You went on and asked other questions about certain things. What did you do after this and what did you do after that? So there's absolutely no basis to reopen discovery. You had full opportunity to find out anything you needed to find out about that email and their position as to when they first got notice, having been aware of that since June 1.
I understand, Your Honor. To answer the court's question, the only evidence that we have of actual notice, which we think is evidence and does establish actual notice, is the admission of the defendant in his deposition that he's familiar with these laws, that he does trademark investigations before he registers the domains, and this email showing that prior to the second UDRP case.
What is the deposition testimony that he does trademark investigations?
Well, I have the deposition here, and if you'd like me to, I can find those references while there's a discussion in the deposition about whether he understands U.S. trademark law, whether he investigates the domains that he's registering to see if they're trademarked. And he says that he does.
And what was his testimony about the investigation as to whether my school was trademarked?
He says that he saw my school on the domain name Cedo.com, or Cedo. It's an auction website for domain names. And that he thought it was a good price and that he registered it. He denies knowledge of knowing that it was trademarked and of the earlier UDRP case, despite earlier in the deposition testifying that he does do these searches to see if they're trademarked. And so we believe his testimony is contradictory in a sense. We believe he's trying to hide the fact that he had actual notice.
Okay. Well, let's go through the bad faith issue again.
Okay.
So they registered the mark in 2013.
I'm sorry, 2009, the mark was registered.
Well, when I'm talking about when the registered the domain name.
The domain name, yes.
Got the domain name in 2013. The statute talks about bad faith intent, but it talks about registration and use. So I want to talk first about the registration. You're saying there was bad faith intent because based on a September 4, 2014 email, you believed he had notice of the registration back in March of 2013. Is that right?
No, we're also saying that his deposition establishes that he generally acquires this notice and that the domains that he sold show that he traffics in trademark domains and that he knows this. His deposition knows this.
And some of those names are things like thugs.org, billy.org, Gatsby, Gecko, Snuggle, Bonnie, Asteroids. Those are all ones that you show that he is registering in trademarked domain names.
Some of the domain names have more descriptive uses than others.
24hours.org,
Well, these,
Predator.org, Rams.org, Ascot.org, Eiffel.net, Ozark.net, Grunge.net, Reinvent.net, Michelangelo.org.
we have tried to point out the domains that trademarks existed on. However, there's also Fujisan.net. There's iWeb.org. There's
iWeb,
well, it's trademarked, Your Honor.
Chalkboard.net.
So some of these are more clear trademark violations than others, Your Honor. But there are some on here that could not be used for anything but to sell to the registered trademark holder. Selfie stick, Comiao, WorldSeries.net. This is trademarked by the National Baseball League. Fountain Blue, spelled the way that it is, trademarked in both U.S. and Canada. And so we've submitted the domains that have trademarks on them, recognizing that not all of these would be found to be trademark infringement if litigated over, but I think some of them would. And that, combined with the admission of the defendant that he knows these domains are trademarked. The defendant may think that U.S. cybersquatting law isn't fair or that he doesn't have to abide by it in Canada, but it is the law, and it's meant to protect trademark holders.
Well, yes, that's true. But the statute requires much more than I have a trademark and the domain name is identical or confusingly similar to my trademark. And
it does.
You know, that's where the extra protection comes into people who are registering domain names. And if it was as simple as I have a trademark and the domain name is the same as my trademark, I win and I get it, you might have an argument here. But the statute requires substantially more than that. And there are, as you well know, many people who use the same trademark in different areas of commerce.
Yes, Your Honor, there are.
Delta faucets, Delta airplanes, you know, that domain name would be pinging back and forth all the time if all you had to do was show I have a registered trademark and it is the same as my trademark.
And in that case, there are different parties using the mark. In this case, there are not. There is no use of the mark by the defendant.
Well, this is not a mark that isn't in use.
Well,
this is
use
not
in
a
commerce.
parked domain name where it is just being stored. It is generating income, and you're saying, and that goes to your intent to profit, because they are profiting from the use of the mark. And so they are using the mark.
Your Honor, all parked domain names that are being passively held are generating revenue.
No. There are many domain names that you go to it and says website under construction, or it doesn't resolve to a web page at all. I can reserve a domain name and not do anything with it.
But the term parked implies that there is a website with cost per click ads. And so if it's parked, it's directing to some parking spot that has ads on it. And that's what the defendant is doing in this case. He's not making use in commerce the way Delta Faucets would be of the Delta generic mark, or Delta Airlines would be. And in a case where intent is difficult to prove, and the Fourth Circuit has said that, we've done as much as anybody can to try and show it. We've shown these other domains. He's admitted he knows they're trademarked. We have emails at least showing some sort of knowledge of the earlier case. And I think that that's enough to get over the intent portion of the standard. And intent is typically supposed to be inferred from the subsequent actions of the registrant anyway. And I think if every ACPA case were lost because you couldn't show the intent of the registrant, they all would be lost. And so,
Well, talk about the use of the mark now.
well,
If I find that there's not sufficient evidence to show that he was aware of the mark, so he could not have had a bad faith intent to profit from the mark that he wasn't aware of when it was registered in March of 2013. He clearly became aware of it in September of 2014.
now Your Honor,
That gets to the use.
one final point. The Lanham Act imputes constructive notice to all domain name registrants. So even if the court were to rule that he did not have actual notice, constructive notice would still be an issue.
Well,
it is
again, that goes to the same issue of I have a trademark. You have notice of it just because I have a trademark.
Mm-hmm.
How does bad faith intent to profit then come into play if you automatically have notice of it through constructive notice by the registration of the mark?
Okay. Well, that moves on to the next point you wanted to get into, which is the bad faith use. And there are a lot of factors that can be considered in bad faith use. And one is legitimate use by the registrant in connection with goods and services. And in this case, the use by the registrant would never constitute use in commerce before the Trademark Office. There are just simply ads to other parties being put on the...
Is the requirement in the bad faith analysis the same as the requirement that you would have in registering a trademark? You've said a couple of times now that it wouldn't be considered use in commerce by the Trademark Office, and I assume you mean for registering a mark.
Mm-hmm.
But what do you have to say that the use has to be the same standard would apply as to use in commerce for under the Cyber Piracy Prevention Act as for trademark registration?
Well, I have the cases that I cited in the plaintiff's motion for summary judgment brief, and these factors are listed.
Well, it says bona fide offering of any goods or services. That's one of the factors.
Yes.
Right. So if you go to the website, myschool.com, there are goods and services being offered at that website.
I would disagree, Your Honor. There are links to other parties who are offering goods and services.
Well, your client's website is the same way. You've got to go to a link to get to goods and services, or at least on the specimen that I've seen.
Well, when you arrive at the website, you have the opportunity to post messages on the website itself, to acquire information from the website itself. The defendant's website differs in that it's no more than just a parked page, a landing page for third parties to advertise. There aren't any actual goods or services on the website, nor is the mark used on the website. I don't believe.
Okay.
If simply registering a domain name were use, then that prong of the standard would be pretty shallow.
Let's go back. You say it isn't used on the website. I mean, the banner is myschool.com, right? Can you see that? It's one of your exhibits. So.
It is, Your Honor. But to constitute a specimen, it has to be shown in connection, close connection with the goods or services. The defendant, all of its pages, all 50,000 of them, automatically put the name of the domain name at the top of the parked page, the landing page, and put these same ads on the page. For the court to rule that these ads were a bona fide offering of goods or services would be to rule that the defendant has 50,000 trademarks for each of its landing pages.
I'm not asking whether the registrant of myschool.com has a trademark in myschool.com. My question goes to whether the use of the domain name myschool.com is a use of the domain name in connection with the bona fide offering of any goods or services. That's what the ACPA requires, not that it be use in commerce as set out in the trademark prosecution requirement.
I understand.
All right. So let's go back to the use after September 4, 2014. Help me understand what your argument is as to why any use of the mark after that time could be considered to be bad faith intent to profit from the mark.
Well, after September of 2014, I would think it would be undisputed that the defendant did have knowledge of the mark, because the second UDRP case had been filed at that point, informing him of the mark. And he continued to use the domain name in the same way he had before, to have these ads
and at that
on the
point
site.
in time, he was also aware of the first UDRP proceeding, right?
He was.
So why is that bad faith intent to profit from the mark, given the knowledge that he had on or around September 4, 2014?
Well, we believe that there were both express and implied misrepresentations made in the UDRP cases. And that's one of the reasons we're asking the court to review them de novo.
Well, I understand. I'm not here as an appellate court to make a decision whether the UDRP proceeding was accurate or not. Okay? And I understand your position on that they are not persuasive, they're not. But the question I'm trying to get to is that being aware of the earlier UDRP proceeding and contesting the allegations in the second UDRP proceeding, how does that show bad faith and intent to profit from the mark from September 4, 2014 going forward?
Well, the behavior was the same, and it was cost per click ads at third parties. He's benefiting at $700 a month, and he's continuing to try and sell the domain name to anybody that he can, and so he's continuing to try and profit in the same way that he was before.
Well, he's had offers to, and he's trying to sell. Let me understand your argument on that. What is your basis for saying that he is trying to sell the domain name as opposed to he has, when asked, responded to inquiries about buying the domain name at amounts that clearly shows no interest in selling the domain name? I mean, I think at least having my understanding of the record is that's what's happened, not that he has actively been trying to sell the domain name.
I believe, Your Honor, that the court needs a little more information on that issue. He was actively trying to sell the domain name by posting it on auction sites, even through the commencement of this litigation. He had it posted on third-party websites where he was trying to sell it as quickly as possible. If the court remembers, there was a motion to freeze the domain with the registry VeriSign because he was doing just that. And I don't have in my head a list of all the places where he's tried to sell it, but he has posted it on Sado, and he has posted it on liveauctions.com. I don't believe that's disputed that he's done that.
Well, while you're up, I want you to address the issue as to the postings that have been made part of the record, either by your client or by your client's cousin, or I want to hear what your position is as to who was actually making those postings.
Your Honor, the postings in question were made, I believe, on September 2nd of this year, after discovery closed, after the litigation had been going for some period of time. If you look at the website there are 37 different posts, and different parties seem to be antagonizing each other. This is not these are not records that I think any party would be happy knowing suddenly we're in front of a court of law, but they didn't expect that at the time. We believe, and of course we can't do discovery on it because it happened after discovery, that some of the posts that were galvanizing my client or his cousin were posted by the defendant, including a post where he threatens to make him bankrupt and on welfare. His posting was in response to that posting. And so this is just an example of the parties bickering, without their counsel's knowledge on the internet. And my client has made settlement offers, including settlement offers that allow the defendant to keep the res. He does not want this litigation to become protracted the way that it has. And so this is just the parties arguing and venting on the internet.
Well, clearly that is completely inconsistent with what that posting was. And it does appear that whoever made that post had information that was of not available to the general public as to the status of the case and what was going on in the case. So it either had to have been your client or someone directly related to your client who made that posting, right?
Yes, Your Honor. I believe it was actually typed by my client's cousin, but with the knowledge of my client.
And trying to make this the most expensive litigation ever, and I mean, those are inconsistent with your statement that your client didn't want this case to turn into what it has turned into. And he's going to appeal it. He's going to do this. He has nothing to lose. I mean, those are troublesome statements for a litigant to be saying.
What I would submit, Your Honor, is that to the extent actions speak louder than words, his actions have shown that he does not want the case to become protracted and expensive. And there have been settlement offers to dismiss the case at a couple of different points because he doesn't want the case to become so protracted and expensive. And if you look at the record, it's actually the defendants who have attempted to protract it to the point that it is now through these discovery requests, through the behavior that is complained of in the reply brief. And so I would ask the court just to keep that in mind in evaluating the issue.
Okay. Anything else that you want to argue in your first go-round?
Not unless the court has additional questions. I'll save the rest for rebuttal.
Okay, thank you. Mr. Westlow.
Thank you, Your Honor.
Your Honor, I know the court is familiar with our papers, and I do not want to belabor the points, but I do want to highlight 3 issues on the defendant's motion for summary judgment. First, the ACPA does require specific bad faith intent to profit, which is not possible without knowledge of the trademark. Second, the registration and use of the domain name here constitutes statutory fair use under the Lanham Act. And third, excuse me, the registration of the domain name is also protected under the ACPA safe harbor. It is well settled that the ACPA requires the plaintiff to show that the defendant had a specific bad faith intent to profit from the plaintiff's trademark. This is shown both by the legislative history and the numerous court opinions cited in our papers. The plaintiff has not provided a single ruling in support of the allegation that bad faith intent to profit is not required in an in rem action, or that constructive knowledge of a trademark is sufficient for an ACPA action as opposed to a trademark infringement action. The discovery responses and documents produced in this matter all corroborate the sworn testimony that the owner of the domain name had no prior knowledge of the plaintiff or of his very limited use of the term my school when acquiring the domain name. There simply is no contrary evidence. And without knowledge of the trademark, the owner of the domain name could not have registered the domain name with a bad faith intent to profit from the plaintiff's trademark. The plaintiff's counsel